So many. So yesterday I stopped at 2014-13 SCC 707 paragraph 28.
28 or 26, sir?
Sorry, 26. I stopped at 26. Sorry. And today, two more paragraphs from this judgment, and thereafter I will move on to others. 26, I already placed it that obiter dictum as an opinion not necessary to a judgment and observation. Sorry.
ফাইলটা দাও।
Oh, sorry.
ওই যেটা তাই দিচ্ছ প্রথম ফাইলটা, লিড ফাইলটা, আর ওই জাজমেন্ট গুলো দাও। লিড ফাইলটা মিন্স WPA 24588 of 2024, আর যার মধ্যে কম্পোজিট এফিডেভিটটা রয়েছে। সাইটেশনটা দেখাচ্ছে তো কি নো ভাই। মিস্টার ধরের সাবমিশন সাইটেশনটা কোথায়? এটা না, মিস্টার ধরের সাইটেশনটা এখানে নেই। দেখুন বার করুন 2014, দেখুন কালকে তো ফাইল করলেন উনি। Yes. Paragraph 26, 27 and 28.
Yes, I would be relying 26. 27 is the Black's definition, and then 28, 29 and 34. And for little bit of fact, so that I can show 35. Well, at 28 I'm starting. 26, that my lord, the definition was there. 27 from Black's obiter dictum, then 28 words and phrases permanent education volume 29 defines the expressions obiter dicta or dicta thus. Dicta are opinions of a judge which do not embody the resolutions or determination of the court and made without argument or full considerations of the point, and not the professed deliberate determination of the judge himself. Obiter dicta are opinions uttered by the way, not upon the point of question pending, as if turning aside for the time from the main topic of the case to collateral subjects. It is a mere observation by a judge on a legal question suggested by the case before him, but not arising in such a manner as to require decision by him. Obiter dictum is made as argument or illustrations as pertinent to other cases as to the one on hand, and which may enlighten or convince, but which in no sense are a part of the judgment in the particular issue, not binding as a precedent, but entitled to receive the respect due to the opinion of the judge who utters them. Discussion in an opinion of principles of law which are not pertinent, relevant, or essential to determination of issues before the court is obiter dictum. Thereafter, kindly take 34. In view of the above, it is well settled that obiter dictum is a mere observation or remark made by the court by way of aside while deciding the actual issue before it. The mere casual statement or observations which is not relevant, pertinent, or essential to decide the issue in hand does not form the part of the judgment of the court and have no authoritative value. The expressions of the personal view or opinion of the judge is just a casual remark made while deviating from answering the, this is important, actual issues pending before the court. These casual remarks are considered or treated as beyond the ambit of the authoritative or operative part of the judgment. 35, if I can just for one comparison with this case, in the facts and circumstances of the present case, we are of the opinion, this is on fact, the refusal of the learned special judge, vide his order dated such and such, to accept the final closure report submitted by the Lokayuk police is the only ratio decidendi of the order. The other part of the order, which deals with the initiation of Chalan proceedings, cannot be treated as the direction issued by the learned special judge. The only reason I wanted that, usually there is no need to place the fact because facts are bound to be different. It's a ratio. That in this case, paragraph 35 shows there was an not only observation, which is an obiter dicta, but also a direction which was not germane to the main issue. That observation coupled with the directions, unlike this case, the one and only directions of the Honorable Division Bench, I would say not one, two, three, strictly in terms with the single judge's order, number one. Number two, modification to the extent of 6 months, comply with. And number three, in further applications, further period of 3 months. This is not coupled with an observation, not coupled with even a direction. In other words, an observation which even did not culminate in any direction.
Yes.
Well, next case is, yes, this is 2018 6 SCC 21. Attorney.
21.
Yes, 2018 6 SCC 21. Paragraph 114. Well, very
114.
114. Very interesting. How to test it, that has been prescribed. It's called an inverse test. Paragraph 114. Well, 114. In order to test whether a particular proposition of law is to be treated as the ratio decidendi of the case, the proposition is to be inversed. Thereafter, inverse is explained. That is, to remove from the text of the judgment as if it did not exist. If the conclusion of the case would still have been the same, even without examining the proposition, then it cannot be regarded as the ratio decidendi of the case. This test has been followed to imply that the ratio decidendi is, this is what is absolutely necessary for the decision of the case, in order that an opinion may have the weight of a precedent. According to John Chipman Gray, there is a quote, it must be an opinion the formation of which is necessary for the decisions of a particular case. Well, if I can elaborate, a portion, even if removed, the operative portion or the ratio decidendi remains as it was. Kindly test in this case. The Honorable Division Bench ultimately directed with one addition. That addition was 6 months. Entire other parts of the Honorable Division Bench's the direction was strictly in terms of the Honorable Single Judge's order and the direction. Now, if the observations are removed, whatever it is, the directions that it has to be strictly in terms of the single judge's order, that remains intact. Meaning thereby, whatever my learned friends are trying to establish, if that is already there in the learned single judge's order, no difficulty. Because the expression, if I can say this, the lackadaisical attitude of the Madrasa Service Commission. The Service Commission took so much of time. They are making one after another application seeking extension of time to implement the single judge's order. That's the context. Therefore, whether as a division bench I would extend or I would not extend, that is the domain. Once the Honorable Division Bench extend the time and do not touch the single judge's order, all that remains is the single judge's order and the single judge's order itself. Any other observations, I would also come, any other observations are only observations, firstly, which are completely obiter dictum, and secondly, even if those observations are removed, the operative portion has got no difficulty to stand on its own. So therefore, inverse this method, if applied, in fact, in our case, there is no requirement of even application of that method, because the division bench, themselves did not ultimately pass any directions culminating those observations. I could have understood that two issues are different. Rights of 73,000. It could be.
No, Mr. Dhar,
Sorry.
we will travel there later on.
Correct.
Single bench passed an order
Yes.
to publish the result, not in that way,
Yes.
publish the result
the
within a
result.
certain time.
Yes.
Commission felt aggrieved,
Yes.
prefer an appeal.
Yes.
At the time of appeal, the commission, being the appellant, chooses it fit
Yes.
not to present the grounds of the appeal.
Correct.
Chooses not to place the grounds of appeal.
Yes.
On the contrary, it prays for extension of time.
Correct.
By the first order, the division bench modified the order of the single bench to the extent
6 months.
Extending to 6 months.
And nothing else.
Nothing else. Absolutely. That is
Yes.
there, not there.
Yes.
So in the first order, I believe there is no order.
Correct.
No, there is no obiter dicta as claimed to have been made.
Correct.
Subsequently, on 2 occasions,
Application was filed.
Interlocutory applications have been filed.
Correct.
For extension of time.
Correct.
Out of those 2 applications, one application contains averment averments.
Some defeat. Let me say.
Averments of regarding some technical flaws, which is the main ground of your defense.
I take it that.
Yes.
X, Y, Z. Sorry.
The division bench, while disposing that petition, unable to comprehend your contention with regard to your alleged technical flaws.
Correct.
Discarded the prayer.
Correct.
However, on a humanitarian ground, extended further time.
For 3 months. Correct. Absolutely.
Let us take a pause here, sir.
Yes.
Would it be your case that if the point of technical flaws as raised by you in that interlocutory application is taken out, the German of the application, not appeal, sir, the German of the application
Correct.
still survives?
Well, that's yes.
The German of your application still survives.
Yes.
How, sir?
Yes, correct. Well, that's Lordship has got to the root of it.
I try to research.
Not try, my lord. As far as, so therefore, my lord, as far as the single judge's order, publish it, following the rule, etc. No difficulty. One candidate filed a writ petition. He gets an order of this honorable court. Let the panel be published. This is the entirety of the context, the domain of this, the honorable single judge's judgment. I question that. Somen Malakar, that's the writ petition, he did not question it. Therefore, as far as Somen Malakar, who is today not before your lordship, is concerned, all that exists for him is the entirety of the learned single judge's order. That is, publish the panel. Now, I try to challenge it, I lose it. While I lose, I come back to learned single judge's order. Now, while losing, I see that 14 days or couple of weeks, I am not able to comply with. So I make an applications. Now here lies the answer of your lordship's precise query. When I am making an application, the entire domain and context of the application is extension of time to comply with learned single judge's order. The domain and the context of that application is, am I bona fide to seek it or get it? I have 1, 2, 3, 4 grounds. I assume all the grounds are found to be wrong. But even then, the context remains not for addition of the single judges anything in the judgment, but compliance within what time. I completely agree with this proposition that the second directions of the Honorable Division Bench with respect to 6 months and 3 months, ultimately there was I counted, it becomes 12th of September 2024. I am bound by that. In other words, by 12th of September 2024, I have to publish the panel, which I did exactly by 12th of September 24. I put a question to myself. I am bound by 12/9/24. Bound to do what? Bound to publish the panel, or also bound to publish the panel in a particular manner, panel being prepared. For the time being, I'm not going into correctness, incorrectness later on. I am bound to publish the panel. Correct. There is absolutely no disagreement on that. And there is also no disagreement with any of us that I complied with it by exactly that timing. But whether my compliance direction by the Honorable Division Bench was also on the method and manner of the preparation of panel, Was it a German? My answer would be method and manner was not German in the second application. It was definitely German only for the purpose of 6 months, 3 months, or 1 year. Meaning thereby, I cannot take a point before your lordship saying that I have a right to publish the panel after 12th of September 2024, and that because that is obiter. No, I don't have a right, because I am bound, and lordships, your lordship is also bound by that. But I say that method of preparation of panel, how I do that.
So, Mr. Dhar, I believe it is your argument that the ratio decidendi in the appeal and in the orders in the applications as filed by you for extension of time is the time limit.
Yes.
Whereas
Deeply.
the Honorable Division Bench finding regarding their unableness to comprehend the technical flaws
Yes.
are the ratio decidendi which can be easily separated.
Yes.
That is your contest. Come to the next point. I understand your contest.
I deeply agree. For this, kindly take my lord 2010. Why now?
On this point also.
Now why? Well, this is a after this. I think the most logical point that should come, because my learned friends, they are trying to utilize their logic on a judgment, on a directions.
So you are.
So I am. Now I am having a judgment where the Honorable Supreme Court is saying that you cannot deduce a judgment and make your that part of the deducing part as a ratio. 2010 13 SCC.
Page number, sir?
88. Paragraph 18. Short. Paragraph 18.
18.
18. No, 18. A judgment, as is well known, is the authority for the proposition which it decides, and not what can logically be deduced therefrom. This quote, thereafter the quote, entire quote is exactly on this. I need not read the other portions. What I'm on is, this is extremely logical on the part of my learned friend to say that reason of not extending beyond 6 months was method of this preparation of panel. That's a logical deducing act.
I can't
Correct.
follow. Will you repeat once?
Yes. My learned friends are trying to submit very logically, and I would have also done the same thing, that the Honorable Division Bench did not extend more than 6 months and 3 months because of the fact that the panel had to be prepared in a particular manner.
That was not the reduction.
That was exactly, but that can be a logical deductions. I'm trying to say that it's nothing illogical in this submission. All I'm trying to say, this is quite logical. It's something like A is a friend of B is a friend of C. So logical deduction could be that C might be aware of A or C could be a friend of A. But that's a logical deductions, possible, very logical, very reasonable. But that is a logical deduction. That is not what is binding on your lordships. That has to be kept separately, because the context of that had got nothing to do with compliance of the learned single judge's order. Only context was whether I'm a fit person to get an extension or not the method of how I do it. I am bound to comply with single judge's order, no doubt about it. If the single judge order contained anything about preparation of the panel,
একটু দেখি ভাই ফাইলটা একবার, রিট পিটিশনটা দিন তো একবার, রিট পিটিশন আর কম্প্রিহেনশন দুটোই দিন আবার।
নাম্বারটা বলে দিন। ওর নাম্বারটা সেভেন না, এটা 2000 দাদু। Correct. এখানে একটু রেডি রাখতে।
Mr. Dhar,
Yes.
I'm reading the portion of the order first. That is the order dated 13 no. First I will read the order date 12/9/2023.
Yes.
And thereafter I shall read the order date 13/6/2024.
Yes.
This is the second and third order.
Correct.
If
12
I take your comprehensive affidavit,
Yes.
page number 150.
156.
Page number 150, sir.
Yes.
Last paragraph.
Yes, madam.
I want to take page number 156, para 3. That is specifically avoid in can 20 on the
Yes.
Clear?
Yes.
At the time of hearing of the instant application,
My lord, is that page number
150,
150?
the comprehensive affidavit.
Yes.
There is the part of the order dated 12/9/2020.
Yes, yes, I've got.
You got the
Yes, I've
idea?
got. At the time.
At the time of hearing the instant applications, several other issues are raised by the appellants, impugning upon the merit of the order of the single bench as well as the appellate court. It is submitted that subsequently certain illegalities and irregularities have been detected, and therefore the court should reopen the entire issues. And till date no application, no application has been taken out, and only application which is pending before us is the extension of time to complete the exercise and the application seeking imprisonment of parties. Sir, I harp upon the words to complete the exercise.
Correct.
Kindly keep it in mind.
Yes.
Extension was granted
Correct.
with a direction to complete the exercise.
Correct. Correct.
Now let us come to the order dated 13/6/2024, internal page number 6. I'm reading it from the read petition. It may
Yes.
be available with you.
Yes, it's available. It's there.
Paragraph 17, middle portion. We are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the learned single bench
I have
as well
heavily
as
marked.
as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared, indicating the successful candidates.
Correct.
So let us take a pause for the moment. I'm not on obiter dicta. I have understood your context. Now, with regard to the argument you advanced right now, what is the issue before the single bench? To publish the result.
Correct.
On the basis of the result of the written examination,
Right.
dated 29/5/2011.
Right.
Single bench directed to publish within a certain time.
Correct.
Now, the order dated 12/9/2023.
Yes.
What the honorable division bench stated? The court is not inclined to reopen the issue.
Correct.
Court application is there, only is pending the extension of time to complete the exercise.
Correct.
To complete the exercise means the exercise which has been
Directed by the-
undertaken in course of the test,
Correct.
followed by the written examination of as held on.
Well, that exercise means following Rule 18. That was the directions of the learned single judge. Preparation of panel.
No. Subject matter of dispute between the subject matter of challenge before the single bench
Yes.
is non-publication of the result
Right.
of the written test as held on
That was held.
29/5.
Basic date stuff.
I'm sorry,
Dates- dates-
29/5/2011. Now,
Basic dates are not done.
time to time extension has been given.
Correct.
Time to time extension has been given for completion of the exercise
Correct.
in relation to that written examination.
Correct.
Then wherefrom you
I can
get
right.
the idea.
That's a that I can
You get the idea
I can hold
of
another
taking further examination.
Correct.
That I intend to know.
absolutely.
That is your argument.
Because if I fail to satisfy on this score, then of course I lose. But my entire effort was, if I fail it on merit decided by your lordship.
Before the single bench was non-publication of the result of the written test taken on 29/5/2011.
Correct.
Single bench directed for publication of the result.
Right.
Division bench upheld that order.
Yes.
Extend the time.
Yes.
Again extend the time.
Yes.
What is to complete the entire exercise?
Correct.
What exercise? The
to
exercise,
publish what already happened.
the exercise which has been undertaken by the commission and which is the subject matter of the original lead petition in the Malakar's case.
Correct, correct, correct.
Your interpretation is that by extending time, the division bench did not tie your hands to take appropriate steps in accordance with law, according to you, in terms of the said notification
If
or
I am
in terms of the rules.
if I am otherwise legally entitled to.
Absolutely.
Correct, correct.
That you have to
Yes,
satisfy.
yes, naturally. Otherwise, I don't have any case. I don't have any case. Correct, correct. Because these are all, I would say, I would not say really technical, but these are not really the head-on collision kind of point. The real head-on collision point is this. If I'm otherwise legally entitled to.
And that is the ratio decidendi.
Definitely.
That is the ratio decidendi.
That, well, that is, if I'm otherwise entitled to, if I can break it, that to find out what was the ratio decidendi in this before the honorable single judge, then before the honorable division bench, then in application. 3 stages. Before the honorable single judge, Lordship has seen the entirety of the writ petition. Method of preparation was not there. So only thing that sticks is going against me is that there is already a written examination. I agree with that. The directions of the honorable single judge was publish the panel. If Lordship may kindly take once more internal page 2 of the single.
The panel publish the panel on the basis of the written examination taken on 29/5/2011, Mr. Dhar.
No.
That no.
No.
Achha?
Kindly take that page. That's the reason I began the submissions with that neuroscience things, that most of the times there are things we expect somewhere and we keep on searching. Kindly take that. Kindly take internal page 2.
2
of the single judge's order. This is, I am seeing writ petition itself. That is also in the comprehensive, wherever Lordship feels.
Your comprehensive.
Then I will refer the internal page.
Page number 94.
Yes. Now, internal page 2 of that directions, starting from accordingly. Lordship has got. May I read? Accordingly, the present writ petition is disposed of after recording that the writ petitioner did appear in the examination of first level selection test Group D on 29th May 2011 and not March 27/11. That is, I would say, typographical. No difficulty on that. But all I'm trying to say, this has got nothing to do with method of preparation of panel. It is something to do with he made a mistake in writing, possibly while drafting petition. No difficulty. Learned advocate for the writ petitions and Ms. Dewan, learned advocate for the commission, and by directing the respondent number 2 and 3 to forthwith intimate to the writ petitioner the result of the evaluation of the answer script, and if he is qualified, then to prepare the panel in terms of Rule 18 of the said rules. There is a difference between prepare the panel on the basis of a examination held on a particular date.
Mr. Dhar, I do agree with you. But with little rider, I request you to come to page number 94. That is internal page 1. You report that the result of the said written examination of first SLST NT Group D is yet to be published.
Correct.
Result means
I've understood that already written
29/5/11.
Agreed.
In the perspective of that, this order has been passed, sir.
Yes. No, I'm not disagreeing with that. But then only question that would come. Sorry.
Definitely. So in the perspective of that order, The single bench directed you to publish the result
Yes.
in accordance with the provisions of the prevailing rules.
Agreed. May I continue with the same sentence? I completely agree with the entirety of whatever Lordship has said, but with only this addition. The Honorable Single Judge's order was publish the panel on the basis of a particular date examination. Right. Right.
So ratio decidendi is whether publication of panel on the basis of the written examination of 29/5/2011.
Yes.
Undoubtedly.
Undoubtedly. There is
no, at that material time, no other issues were there.
Correct.
Not even in the periphery.
Right. But then I put a question to myself. Is it a ratio that in the process I don't have any right to widen the pool? When I'm using the word pool, Lordship, kindly remember yesterday Lordship used in word elimination, screening. So this was for the purpose of screening. 1,43,000 was the total candidates. This number will not go anywhere. This is only everyone is eligible. All are eligible. Just because it is unmanageable, I do a preliminary examinations just to, in your Lordship's word, just to eliminate. And I prepare a pool for competition. From 1,43,000, it straightway comes to 26,000. That is the pool who would be competing to each other. I say that the ratio of the Honorable Single Judge's judgment is not if I expand the pool for any other sufficient reason if I can satisfy.
So sum and substance of your contention is, Mr. Dhar, the single bench judgment and the division bench 3 successive order impliedly or expressly did not restrict the commission to complete the process of examination in accordance with the recruitment rules, of course, within the time frame.
Absolutely.
That is your bone contention. I understand. Very good.
Well, for that, I have a direct judgment. But before going to that judgment, I was কোনটা ছিলাম জানি? কোনটা বলছিলাম? না না সেটা জানি। 08, no? This one. But there would be little break in the flow that Lordships created.
Because I am the creator,
No.
because of I am putting so much
I said
question.
no, the Lordship.
Maybe sir, unnecessary. And
Well,
you will see that I used to drink water
No,
to assimilate your arguments.
No, I think all of us, we are actually enjoying it. Because I don't think that, of course, but if we can provide some logic, some reasonableness, then it sounds good. Now, if I say something which completely rational, then I think we will just start taking nap, kind of. And that goes in both ways.
Very good, sir.
Well, I said that when I was with the other judgment, thereafter Lordship asked me to see that division bench, single bench, and I entered into this part. Uh, I started with the orbiter. There are 2-3 judgments. If I can just finish and come exactly there. Well, this has a why orbiter of a, because well, I must say one thing. There is an exception. If it is an orbiter dicta of the Honorable Supreme Court, that would be binding before your Lordship. So, because it's an orbiter dicta of the High Court, it no way binds before your Lordship. So, my entire argument would be that if at all I am otherwise able to show that there was enough reason in the recruitment process to widen the pool, if your Lordship finds that I have not violated the law, in that case, this judgment may not be an obstacle for me. Neither it would be anyway stopping your Lordships to protect me if Lordship sees that. Well, 2008 11 SCC 753.
2008 11 SCC
2008 11 SCC
page
753. Paragraph 22. 22. That why this is the, my lord, the very logic. Why? Paragraph 22. The judgment is not a statute. So, while delivering judgment, as the honorable judges' liberty are there to express, but that does not necessarily mean that every word, every sentence has to be taken as Lordships wanted to be part of the ratio, thereby binding. Liberty is there to express, but entirety of the sentences and the words, unlike a statute. If it is a statute, then even a semicolon, even a comma, a full stop, everything has got its own impact and capability to change. But for a judgment, it is the cumulative factor in the context of cases. In the context of the facts. Not the one paragraph, 2 paragraph. Paragraph 22. The judgment of a court, it is tried, should not be interpreted as a statute. The meaning of the words used in a judgment must be found out from the backdrop of the fact of the each case. Well, I pause for a moment. Fact of the each case means preparation of the panel was not part of the writ petition. Inaction was a part of the writ petition. Now, preparation part, I will come later on. Sorry. The court, while passing a judgment, cannot take away the right of the successful party indirectly, which it cannot do directly. An observation made by a superior court is not binding. What would be binding is the ratio of the decision. Such a decision must be arrived at upon entering into the merit of the issues involved in the case. Well, this part, the court, while passing a judgment, cannot take away the right of the successful party indirectly, which it cannot do directly. But there is a proposition that if something cannot be done directly, that also cannot be done indirectly. There is a judgment also on that. And there is, I believe, there is a quite a common sense prevalent everywhere. If I cannot do something directly, I am not supposed to do that indirectly. If that is so, then if in the screening time, in the preliminary screening, which was not real competition, if I find that there is a chunk of pool which were for my own fault, despite being eligible, could not even participate in the competition. Now, whether their right can be sealed in a situation where this was not even an issue before the Honorable Single Judge, not even an issue before the Honorable Division Bench.
I am with you, Mr. Dhar. I am with you. But
did I have a good
try to remember the settled position of law. The writ or writs which are being issued by the High Court under sitting in Article 226 of the Constitution of India
Yes.
is highly prerogative in nature.
Yes, it is.
And it is discretionary also.
It is. It is.
I believe you agree with that.
Yes,
It is
yes.
a settled
No
proposition.
doubt about it.
Highly
Lordship can-
prerogative and discretionary
discretion.
one.
Lordship can afford to look other way, even if he has.
Absolutely.
Yes, yes.
If I accept your contention,
Correct.
if I accept your contention regarding obited dicta,
Yes.
if I accept your contention with regard to the your explanation or with regard to your interpretation, I must say, regarding the single bench division bench order.
That would be my starting from zero.
Absolutely.
That is not a
Then
plus. I understand.
If you are so generous, sir, if you are so generous, what prevented you to approach the division bench in order 47?
But I'm coming to that.
Keep it in mind. Keep it
Yes,
with mind.
I would.
Because I'm sitting in a read jurisdiction.
True.
You are before a read court.
True.
You are before if you are a civil court.
True.
If you are before a trial court, the position could have been otherwise.
True. Well, may I answer? What?
Not now. You may also give answer.
Well, one answer that was suddenly came into my mind is
Yes.
that no matter the Honorable Division Bench have made some expressions about my conduct, my inordinate delay, various aspects, but ultimately the Honorable Division Bench also said that I have to comply the order of the Honorable Single Judge strictly.
I agree.
Therefore, while complying with the order of the Honorable Single Judge, if I find that my hands are otherwise not tied, I am not required to go before the Honorable Division Bench. But if I find my hands are tied, then I have to. Now, whether my hands are tied or hands are not tied would depend upon whether the judgment of the Honorable Division Bench was a ratio on how to prepare the panel. I think my respectful submission would be the ratio was confined to two things. Examination was held on a particular date.
Preparation of the panel, publication of result within a certain
time.
These two must have.
Yes, exactly.
I understood.
Yes. This, exactly. This.
Properly understood at all.
Yes. No. Exactly that. So therefore, now I come at a zero. Zero in a sense, now I have to build up a case that under law, as established, if as a selector, if I find that there was a pool, may I come, give me just once. Next here. 7. Yes. Well, next is 2016. Sorry, 2016 4 SCC 696. 2016 4 SCC 696 paragraph 25. এটা একটু নেবেন judgment. (25) and 26. 26 was that it has to be confined to the facts of the said case, and 25 on specific, may I just place it, short paragraph. paragraph 25 and 26.
Yes, sir.
In Krishna Kumar versus Union of India, the Constitution Bench, while appreciating the concept of ratio decidendi, adverted to the principle stated in such and such, an observation made by Sir Frederick Pollock, and thereafter laid down thus. The ratio decidendi is the underlying principle, namely, the general reasons or the general grounds upon which the decision is based on the taste or abstract from the specific peculiarities of the particular case which gives rise to the decision. The ratio decidendi has to be ascertained. Sorry, I
Yes, yes,
just
you are absolutely online. Ratio decision has to be ascertained by an analysis of the facts of the
I
case.
just missed my soft. That portion was somehow cut out. Yeah. কোন জায়গাটা? Yes, it has to be ascertained by an analysis of the facts of the case and the process, first facts of the case and process of reasoning involving the major premise consisting of a pre-existing rule of law, either statutory or judgment, and a minor premise consisting of the material facts of the case under immediate consideration. If it is not clear, it is not the duty of the court to spell it out with difficulty in order to be bound by it. Then Halsbury, there the Lordship may skip this portion, straight away calmly come to 26. Viewed in the backdrop of the factual score in entirety, we are of the considered opinion that the decision in such and such has to be confined to the facts of the said case. Yes, I know my next hurdle would be exactly that Lordship has precisely asked me. I would next contact. Then be number table 5. Yes. Madam, next is I will just refer the paragraph. It is a 2006 5 SCC 167. 2006 5 SCC 167, paragraph 12. Paragraph 12. Well, 6. The first 6 lines I may skip to shorten, because this is on the point of logical deducing that is not having a binding effect. Well, starting from 1, 2, 3, 4, 5th line. A decision, it is well settled, is an authority for what it decides and not what can logically be deduced therefrom. Logically, it may be deduced that the honorable, sorry.
The same line.
Yes, same line. Well, I'll just say one sentence on this, then I'll move on to that point. Well, logically, this can be said that honorable single judge, having seen a particular date to be for the examination, wanted the directions of the honorable single judge to be such, publish the result exclusively on the basis of one-day examination and that examination alone. That could be a logical conclusion. But that's a logical deducing. That's not the ratio of the honorable single judge. The honorable single judge's context contained couple of components. One such component was an date of examination. And thereafter, the honorable single judge did not enter into any other arena, prepare following the rule, publish the panel. So it is possible to logically say that it means the Honorable Single Judge held your publication has to be only on the basis of that examination and that examination alone, because I have published based on that examination also. It's not that I did not. Question.
There was no scope for the single bench to consider any other matter, because on that very particular day, the
There was-
subject matter is
Correct.
29/5/11
Correct.
examination.
Now, if I clarify one fact, on the basis of 26,000, that written examination, I prepared the panel. Only grievance of the writ petitioner is that why I also added some others while preparing the panel based on a separate examination. Effectively, what I understood, they took
So
the
you prepared composite panel.
I prepared. I have the exact data in the
No, you prepared a composite panel which is the outcome of two examinations.
Well, I give the exact.
Composite panel has been
I total ultimate final merit list was of 295, and what I found that from the broadened pool of subsequent examination, 51 have come. That's leaving aside.
You
So
have prepared only one panel.
I prepared one panel.
For two
I
exams.
correct. Two examinations, one in 2011, another in 2024.
Which is not
Correct. I say that permissibility for holding another examination could be a logical deduction. Sorry, impermissibility could be a logical deduction. But that was not what the Honorable Single Judge held. That was only a component of a fact. All the Honorable Single Judge held that publish the panel following Rule 18. So under 18, if I am barred to do anything and I must hold only one examination, then of course I am barred. If I am barred by rule, I am barred. But well, may I now directly come to the point? This is well, this is 2000. This is permissibility of re-evaluation. Before placing the judgment, if I can just, my lord, give the context why I am placing this judgment. Now I have to satisfy your lordships, leaving aside the Honorable Single Judge's directions and the Honorable Division Bench, independently. Now I'm trying to satisfy that what I did, that was permissible and that was in accordance with law. For that purpose, I will go to the rule later, 2013-14 SCC 494. Paragraph 18. This is that at any stage of irregularity, if I find that, I can go for evaluations or whatever that is necessary, unless it is decided otherwise in a particular case. Paragraph 18. In respect of the respondent board's propriety in taking the decisions of re-evaluation of answer scripts, we are of the considered view that the respondent board is an independent body entrusted with the duty of proper conduct of competitive examinations to reach accurate results in fair and proper manner with the help of experts, and is empowered to decide upon re-evaluation of answer scripts in the absence of any specific provisions in that regard, if any irregularity at any stage of evaluation process is found. It is settled law that if the irregularities in the evaluation could be noticed and corrected specifically, an undeserving select selected candidates be identified and in their place deserving candidates be included in select list, then no illegality would be said to have crept in the process of re-evaluation. The respondent board thus identified the irregularities which had crept in the evaluation procedure and corrected the same by employing the method of re-evaluation in respect of the 8 questions, answer to which were incorrect, and by deletion of the 8 incorrect questions and allotment of their marks on pro rata basis. The said decision cannot be characterized as arbitrary. Undue prejudice indeed would have been caused had there been re-evaluation of subjective answers, which is not the case herein. But here, my lord, if I frame a question and then, my lord, I attempt to answer. As a selector, in the process of this selection, if I find an irregularity, do I have a right to correct it or I don't have a right? Now there, I would, my lord, address it in completely two separate compartments. The first compartment is the compartment of elimination round. So a competition will take place from 1,43,000. Elimination round made it a competition for 26,000. Now, on affidavit, what that I've disclosed is there was, my lord, 3 sessions: session 1, session 2, session 3. In 3 sessions, question papers were completely different. Class 8 standard, basic arithmetic, basic English. Ultimately, what do I need? I need a peon to work. I'm not going to choose a rocket scientist. So therefore, I need to know that whether he would be able to do the job. Is there only one way of deciding that this is the way that a peon can be selected? The answer is no, because in this case, there are completely 3 question papers. I'm saying now even in the preliminary. So therefore, in the kindly assume, it's not that Lord, my rule doesn't say that I have to go for elimination round. I have done it so that I can reduce my tasks. In other words, 1,43,000 had the legal right based on my advertisement because of their eligibility to participate in the competition. So now while they participate, because of my mistake, I had an answer key of session 2. I have used it for session 1 and session 3 and session 2. So because of my, I would say, gross mistake, that happened. Now, because of that mistake, Lordship will look at the number, because in elimination, nobody eliminates in such a drastic way. From 1,43,000, it becomes 26,000. Then actual competition starts. Now, this 26,000, one of the points my learned friends have taken, that how there can be 2 question papers. Even in their
Question papers in
retaining, in retain examination.
Preliminary
No,
exam is not in notes.
I'm on retain. In retain, there were separate 2 question papers. I could have understood that there is a 1 question paper. In retain, there was 2 sessions. There was a gap of 1 hour, so that this is not copy paste or whatever information is not leaked. 2 completely separate question papers were set, keeping in mind that I'm going to appoint some peon to understand whether he knows the little bit of arithmetic or English. There are various ways and methods. So I chose that. Now, if Lordship lifts the veil of their argument, Lordship will find what the petitioners are trying to say, that there is a pool of candidates of 26,000. They are trying to say that that pool cannot be expanded. Now, this 26,000 has come because of this elimination round, and that number will not go with anybody. So practically, they are trying to say that we want a competition with less persons, because all are eligible. It's not that anyone is not eligible. All are eligible. All I try to make this submission that assuming an innocent candidate who was in session 1 or session 3. In fact, when I was trying to read it thoroughly, I realized out of 26,000, there is bound to be many of them, they got a chance by fluke, because the answer key was only for one session, A, B, C, D. Now, it is bound to be for in a random way it has been done. Because today I have the original OMR, I have the original answers. And this has been discovered by the selector that we made such mistake. The pool should have been 73,000 more. Because in a very for my mistakes, they were not allowed to even, I would say, participate in the competition. So this is a case where they were not even allowed to participate in the competition. So a pool was made, which was a lesser competitive pool. Now, kindly consider, once this 26,000 is not touched, because I know that I cannot touch, because there is an order of the Honorable Single Judge, there is the direction of Honorable. So I do not touch 26,000. All I do, which otherwise I could have done the entire examinations by 1,43,000. I admit my mistake. Now, kindly visualize in a situations, assume that I am a very bona fide honest selector. Assume that. It's very difficult to assume nowadays, but kindly assume for the time being that I am a very bona fide honest selector. I discover for my mistake some
And one actually adjective more, bona fide, honest and prudent.
and prudent.
Please spare me for 2 minutes.
Yes, yes.
No, very good.
actually 120 seconds.
Judicial hour is very precious, and many people are waiting to looking towards for getting justice. Why should I?
But may I just, so this would be little going away from, I don't know. I have a feeling. Absolutely, this is the correct and right to approach of that. But there has to be a fundamental, I believe. I'm not. I would not be able to change the world. I think this is a paradox of being attached and detached. All I'm trying to say, no matter what is done by your lordships or anybody else in the world, uh, no one is going to change it in any way.
Be that as
Maybe
it may.
because what we consider to be good, because there is a large amount which is bad. So scheme of there is always a bigger scheme of things. If I just say one thing, like everything that we are perceiving, that is based on our tools that we have. Now lordship is seeing, it's me, your lordships, we are seeing here tools and everything. Now kindly assume for a moment that your lordship is having a let's say microscope, and me too, and everyone here. So all of us would be seeing the millions of more other things. Now what is the truth? Those are there. So what we think is fundamentally carved and decided by our ability to perceive it. We think in all things, lordships from lordship point of view, I and each one of us in our, I think there comes the real answer in spiritual. Deeper.
Yes, Mr. Din, one thing I perceive rather
Yes.
that at the end of the day, I must be very clear to my conscience.
There is no end of the day.
Be that as it
That
may.
is that I'm on that.
Till I
There is,
take my last breath, nobody can say that whether I'm a right person or wrong person or I'm a correct person. But till then, on each day or on end of the each day,
all my hearts out.
I must be conscious. I
Agree.
must be
True.
answerable to me, and
True.
I must be very clear to my conscience.
True.
And I believe our conscience is the greatest God.
So it is. It is.
Yes, sir. Let us start.
Yes. Well, I was on paragraph 18 on the point that at Lordship has that copy.
Oh, yes, yes.
This is 2013. আসলে বলবো 2013-14 SCC 494, that permissibility, if I find an irregularity, I just want your lordships to see this 4-5 words: at any stage of evaluation process. I'm assuming that is not assuming, that is in respect of a competition. But I have a better case. There is a competition part and there is an elimination part. So all I'm trying to make this submission, that assuming for the time being, which I said, which is very scarce, as a very bona fide, honest and prudent selector. May I take a little bit of water?
Sir, please.
Assuming that I am such honest integrity, and I have discovered that because of my mistake, I have completely ousted 73,000 from entering in competition. So in other words, what I have discovered is, in the state, there are so much of unemployment problem, and there is a huge everyone wants job for variety of reasons, and ultimately for survival. So what I see is that for my mistake, I am not even giving them the opportunity to take part in the competition. Kindly assume if that is so, what do I do? I may have two options. One, because of this, cancel this entirety. In fact, in the very conference when they were holding, I did say that I will open the entire card and I would be praying before lordships, whatever would be the right course. I may not be able to make submissions only on the way they want me to say. That could be one option. The other option would be, once I find that this is an elimination round, so what I am doing is, there is a pool of 26,000 only, which was supposed to be 1,43,000. I am expanding the pool by 73,000. Why I am expanding it? Because of the reason, it's not I am giving them an extra marks. They are otherwise all are eligible to compete. Then they're not getting anything extra. It is like they are not eliminated. Only that. And I have the records with me. I have the originals with me. I have the answer key. Even I am aware that in that 26,000, bound to be some persons would not have come because of this wrong answer key. But I don't want to touch them for two reasons. Reason number one is, after all, this is a pool of competitions. I need 297. So this part, that at any stage of evaluation process, sorry, if any irregularity at any stage of evaluation process is found, can I remain silent to that? Thousand ten to the. Data. Dinesh.
So sum and substance of this part of your submission is that by publication of two notices under challenge, you have practically permitted those persons to appear in the written examination who have been mistakenly left out, and by your action, no prejudice has been caused to the present writ petitioners, because by issuing those two notices and by your actions followed by those two notices, the persons who appeared in 29/5/11 have not been eliminated. That is your bone contention, I believe.
And there is a 2010. There is an exact judgment on that. Yes, that's exactly I'm saying. 2019, 12 SCC 798.
2019.
This gives the reasoning. Why?
2019.
2019, 12 SCC 798. paragraph 25. 2019 12 SCC 798. No legal right to say that I must
Give me
complete.
a second, sir.
Sorry.
Yes, sir.
Well, sorry, I said 25. There are 25, 26, 27, and 28. First 25,
25, 26,
27, and 28. In this 25, in this factual basis, firstly, it needs to be examined as to what is the status of the appellants who were called for document verifications over and above the number of posts advertised. The circular dated such and such is to the effect that 20% candidates are to be called to avoid the shortfall in the panel, and that merely calling a candidate for document verifications does not in any way entitle him or her to an appointment in the railways. It is also contemplated that replacement panel, kindly mark, replacement panel shall include only such number or reserved unreserved candidate as have not turned up as per original panel. Therefore, the 20% extra candidates were called to substitute the candidates who do not report within the joining time granted to the selected candidates. Such candidates at best can be said to be the candidates in the waiting list of the candidates to be called for appointment if the selected candidates do not join for or the other reason. 26. The next question is as to whether a candidate acquires any right to appointment being in the merit list. Here, that doesn't even come. It is even preliminary elimination round. Such question has been examined in a number of judgments time and again by this court. In a judgment reported at such and such, it has been held that the state has a right not to appoint a candidate even if his name appears in the merit list. But thereafter, the entire court and Lordship may skip that. And then kindly see paragraph 28. Referring to Shankarsan dash, it's a constitutional bench judgment. Paragraph 28 of this court held that the notification for an appointment merely amounts to an invitation to qualified candidates to apply for recruitment, and on their selection, they do not acquire any right to the post. It was held thereafter. Kindly see, it starts with it is not correct. So, not is the important. Not correct to say that if a number of vacancies are notified for appointment, an adequate number of candidates are found fit, the successful candidates acquire an indivisible right to be appointed, which cannot be legitimately denied. So, this is not. Ordinarily, the notification merely amounts to an invitation to qualified candidates to apply for recruitment, and on their selections, they do not acquire any right to the post. Unless the relevant recruitment rules so indicate, the state is under no legal duty to fill up all or any of the vacancies. However, it does not mean that the state has the license of acting in an arbitrary manner. The decision not to fill up the vacancies has to be taken bona fide for appropriate reasons. And if the vacancies or any of them are filled up, the state is bound to respect the comparative merit of the candidates as reflected at the recruitment test, and no discriminations can be permitted. The correct position has been consistently followed by this court, and we do not find any discordant note in the decision such and such. In this context, if someone who is already impaneled, if he doesn't have a legal right, the writ petitioners to say that the competition has to be in a smaller pool. State has a right not for a sufficient reason not to go for it. They are not affected because none of them none of their names has been deleted. All of them are there. Their entire grievance is, how can I add new persons? My answer is that I am not adding a new person as such, not that anyone. I am adding all the persons who were eligible, who participated, and who were left out because of my mistake. So therefore, a smaller pool becomes a larger pool for the competition. They don't lose anything. Kindly visualize that part. And that was never the ratio before the honorable single judge, before the honorable division bench.
Definitely not.
This was not. I understand that my reason has to be bona fide. That's the reason, my lord, I assumed a case where honest, prudent, proper selector, if he really discovers there is an irregularity, my lord, it would be extremely difficult for an honest person, honest selector to close his eyes. Singular product, singular product 2000, singular product content, এটা প্যারাটা আছে পড়ে no legal right. Yes.
Yes.
Now kindly see, my lord, why I was saying the pool. This 2015-16 SCC 778. On screening. 2015-16 SCC 778. Paragraph 19.
19.
19. দেখে না কোনটা? Paragraph 19, 19.
Yes.
In our opinion, the conclusion reached by the High Court is erroneous. The preliminary examination for shortlisting candidates who would be eligible to take the Rule 3 examinations has no statutory basis. Neither the Kerala SNS rules nor the rules of procedure contemplate such preliminary examination. However, this code recognized existence of legal authority to conduct a preliminary examination wherever an unmanageable large number of applications are received for filling up a limited number of posts. In this case, in our case, 1,43,303. Because of my mistake, I reduced it to 26,000. My correction of mistake, around 1 lakh.
Around 1 lakh who have been qualified to appear in written examination.
In the yes. I have the exact.
The 29/5/11 written examination was restricted to 26,000.
Yes.
And after
When you
after
discovered
after reviewing, it comes to,
when you found with the key with the original
I
OMR,
understand.
yes.
It reached to
it reached to কত? 98,500 and
say 1 lakh.
say what? That's 1 lakh. Oh, right, it's there. And I found that the how, so the entire attack of the writ petitioner is that no, competition has to be within the 25,000, which was never before any of the courts. Kindly, Lordship, visualize these situations as a selector. As the Honorable Supreme Court various judgments suggest, if you find an irregularity, you can also do it afresh. But I found that was only in the elimination round. Therefore, I can save the baby by correcting the course. The only real effect that happens that for 297 Group D posts, the competition could have been restricted to 26,000 for my mistake, and when I rectified it, the competition became among 1 lakh.
And on account of your rectification, you are arguing that the writ petitioners have got no
Are not
authority to
affected.
challenge, no authority to challenge those actions in absence of any in the absence of any specific case of deprivation, especially when those writ petitioners have got no indivisible right to their selection.
Yes.
That is your content.
Yes. And Malad, may I just complete this and move on? Preliminary একটা আছে না? কোনটা 2013 16 SSC এটা. There is one more. 2013 on this preliminary screening, 2013 16 SCC 702. 2013 16 SCC 702. The paragraph 14. That this is little more relaxed. Lordship, may kindly come to page number 710, because it's a long paragraph. It starts from a different page. Page number 710. Original paragraph 14, which cannot be seen here.
Very good.
Lordship will see second paragraph. The placitum B.
Yes, the Supreme Court.
Yes,
further
Supreme Court further observed such and such case. By reason of providing for a preliminary examination, the right of the reserved category candidates has not been taken away. The means cannot be allowed to defeat the ends which the constitutional scheme seeks to achieve thereafter. With regard to conducting the preliminary exam, which is not a part of the main examination, the Supreme Court observed, then court, indisputably the preliminary examination is not a part of the main examination. The merit of the candidate is not judged thereby. Only an eligibility criteria is fixed. The papers for holding the examination comprise of general studies and mental ability. Such a test must be held to be necessary for the purpose of judging the basic eligibility of the candidates to hold the test. That's why different question doesn't matter. For everyone, even for them also, different session, different question, because it is a more relaxed.
How it is delivered, Mr. Dhar? Nobody is questioning the holding of written preliminary examination.
No, I say written examination also. Written examination for the writ petitioners, just a factual information which they were incorrect.
No, the analogy of holding preliminary examination cannot be extended to written examination.
No, I'm not taking that. I'm saying that in the written examination, the petitioners participated.
29,511.
Yes. And they are saying that in 24 examination, fresh round of written examination based on a separate question paper. So level playing factor is disturbed. My response to that is, when they participate in the written examination for them was held in 2 sessions with 2 completely separate question papers. Therefore, the level playing factor would be disturbed by separate questions, may not be available to them. They are the product of separate question papers.
What is the pleading to other effect?
Well,
What is the pleading to that
there
effect?
may not be. That's a fact. I can show. That's a fact.
No, how can I accept that fact, sir?
I
There
can.
must
I
be.
can. But I,
This is a very.
but I can bring the original also. I can, because it's a rich quote. I can bring the originals because I take the response. This is something that I won't be making. I can produce
I'm
anything
not on that, sir.
because because it was troubling.
I trust Mr. Dhar, but that trust I don't have upon the litigants.
Correct. Well, let them. I think they will not disagree on fact on that. তোমরা একটু জেনে নাও, দুটো সেশনে আলাদা কোশ্চেন পেপার হয়েছিল।
But how could I know? Because of that, I participated just for.
No interruption. Yes,
In my reputation, every.
But there is no pleading to that effect.
In my
But
reputation,
I'll see to that. If I'll see to that, but it's a fact because I remember I even today I specifically asked the secretary.
Be that as it may, but the reported decisions you have cited,
Yes.
those are all restricted regarding justification of preliminary examination.
Yes.
How can you take the analogy of those reported decisions which are in the perspective of the preliminary examination into the written examination?
Yes, my lord, I'm connecting that. I have also, my lord, placed a judgment that if I find an irregularity by me. Now, lordship is on pleadings part. Now, on affidavit, I have said that there is a mistake happened.
Mr. Dhar, let me recapitulate.
Yes.
Just advancing this type of argument, you have argued that even a successful candidates have no indivisible right to his selection.
Yes.
Your next submission on the same point was that by publishing the notifications are not challenged,
Yes.
you have rectified all your own mistakes.
Yes.
You hold fresh scrutiny, permitted say 75,000 more
Yes.
to participate in the written examination.
Yes.
Thereby,
Without affecting them.
absolutely, thereby no prejudice is caused to the writ petitioners
Yes.
before this court.
Yes.
That is your submission.
Yes.
Now you are arguing on the level field.
Yes.
You are arguing on the level field.
Yes.
You relied upon 2 reported decisions.
Yes.
Those are restricted to preliminary examination.
May I say, sorry, it was my mistake. These judgments, I am not using this judgment on the point of level playing. The only purpose of placing this judgment of preliminary is this, that preliminary examinations are permissible without there being a rule.
Nobody is challenging, sir.
So therefore, addition of 70,000, not from new, from original 1,43,000.
I understand your contention, sir. I understand your contention. That
That's
is
separate.
according to you, it is permissible, it is within your periphery, within your power, within the rules. No prejudice is caused, no indivisible right is altered.
Yes.
Now come to the point of level playing field.
Right.
That I had to say. But don't equalize this with that.
No. Right. So it was my mistake. Now, on level playing factor, well, I will definitely see the pleadings. I said that one of the allegations is separate examination, separate question paper. Therefore, level playing factor is disturbed. That's apparently it's a very, I would say, valid argument. But then, if Lordship goes further deep into it, then the first question would be, in the entire process of this examination, whether one question paper is a phenomena or separate question paper is a phenomena. The answer is, from day one, whether it is a preliminary or whether it is a written examination, in both examinations, there were separate question papers in separate sessions. But Lordship's query is where I have pleaded. Well, I will check it and I will see it. I will get the original records also, if Lordship permits me.
And the rule permits you.
And
Rule permits you.
yes, that I have to satisfy. I am coming to the rule. That another argument is, I think Mr. Shamim has taken that it's one written. It has to, may I say? I think
There has to be one go.
Sorry?
One go.
It has to be one go. Correct. It's a very good point, but I have a good answer. I mean, I'm prejudiced with my answer. Let's see whether good or bad. True. No, that. Yes. The copy of the rule is with your Lordship. I think one rule.
I am
Yes.
not.
Yes. Now, my learned friend relied on Rule 16 to say that, first I place that it doesn't talk about tests. It's one test.
একটু ওই রুলটা দাও তো ওইটার সাথে রয়েছে রুলটা ওই রিট পিটিশনার যে এটা দিয়েছিলেন না ওইটার মধ্যে রুলটা রয়েছে So on level playing field, we will argue later.
Level playing field, I think the fact itself would show, and I do believe, my lord, that there are many advocates. I believe they themselves would say, on fact, I think as an advocate, on fact, there should not be any difference.
Good.
So that,
Anyway,
yes. So arrangement of written, kindly see, first, first rule 5.
proviso to 16 expressly permit you to hold screening test.
Yes.
So the reported decision which you have cited may not be necessary because
May
it
not
permits you.
Right. I say that it's a provided commission may hold screening test before holding written. So my only purpose was that I could have gone with 1,43,000 also.
So let us read rule 16 once.
Yes.
Once more says.
Holding and conduct of written test, the commission shall hold written test of all the eligible candidates. Lordship may kindly mark eligible, all eligible candidates. And this is with shall. The commission shall decide the procedure and the manner of conducting the state region area level selection test and prepare detailed instructions in this regard in accordance with the provisions of the Act and the rules made thereunder. The commission shall select the examination centers, appoint officer in charge for examination centers, custodians of confidential papers, supervisors, venue in charge, invigilators, observers, and make necessary arrangement for the conduct of examinations, here it is in plural, and collection of answer script sheets, provided that the commission may hold screening test before holding written test in case the number of candidates applicants in any category or post is huge, particularly in case of selection of clerks of group D staff in the manner as the commission may deem fit and proper. First, I am bound because of the word shall. Kindly connect these 4 words. 16.1 shall hold written test of all the eligible candidates. First, I take my learned friend's argument. Test means one, singular. It doesn't mean plural. My direct answer would be that General Clauses Act, Section 13, there are plethora of judgments. It includes that. One. Second is, shall hold doesn't give me a right if I find someone is eligible. It's a mandate. Because on affidavit, I have found it was my mistake, someone was left out. Now there is a conflict. 16.1 mandates me shall hold written test of all eligible candidates. Now, who are eligible candidates? The eligible candidates commission's affidavit is based on the screening 73 and 26. The petitioner's case is eligible candidates is only 26. The only conflicting because of these two facts is my admission of error. There is the entirety of the argument of the writ petitioner is on the judgment of the Honorable Single Judge and the Honorable Division Bench. There is no answer by the petitioners that if I find an error, whether this shall gets diluted. Do I lose my power to rectify? Do I have the power not to hold the written test of the eligible candidates?
The answer is on the next line.
Yes.
The answer is on the next clause.
Yes. The commission shall decide the procedure and the manner of conducting the state, region, areas level selection test and prepare detailed instruction in this regard in accordance with the provisions of the Act and the rules made thereunder. Yes, sir. Yes, yes. Yes, yes. Various district. Yes. Correct. Yes. Yes. Yes.
Regarding the procedure and manner.
This
Holding, I understand your contention. Commission will hold written test of all the eligible candidates.
yes. So therefore, it's
According to you,
yes.
after screening, you found more eligible candidates.
Yes. So therefore, I have to.
I understand your contention. Next answer. So your answer is lying there
Yes.
The commission shall decide the procedure and manner of conducting this test.
Yes.
The manner of conducting the second test
Yes.
raises a question,
But here I have
question in the mind.
I have a good
And the manner of conducting examination must be supported by
my decision, my
decisions, resolutions of the committee.
absolutely. May I answer this? I think I may have a good answer to that. Rules of the game cannot be changed once.
I'm once again, I cannot.
No, please. Yes, yes.
What I want,
I said
the
we.
commission shall decide the procedure and manner.
Yes.
So show me their decision.
Yes. Yes. I understand. May I first say this? Rules of the game once started cannot be changed. Now it has been the 5-judge bench. There were some divergent of views. It was sent before the Honorable Constitutional Bench. Now the Honorable Constitutional Bench have affirmed it, saying rules of the game. Once the game has started, now the rules of that has to be the same. So some rules were there when on the basis of this 26,000 came, because nobody is questioning how 26,000 came and on the basis of what rules. That's naturally. All I'm trying to say that when 73 came, I did not adopt any separate rule. I followed the same rules. I followed the similar procedure that I followed for 26,000.
Mr. Dhar, I'm sorry to say I'm not convinced.
Yes.
The rule permits you to hold examination, no doubt of it, sir.
Yes, yes.
The rule but the rule permits you to prepare procedural manner.
Yes.
I'm not on rule, sir. You are absolutely within your authority as per rule. But I am harping on the procedural manner which permits you
Yes.
to hold the second examination on account of your
Mistake.
detection
Yes.
of your mistake.
Yes. But I've understood.
When you have decided to hold examination of particular numbers of candidates
Yes.
instead of holding a fresh written examination.
Yes.
Had it been such a, it could have been, because the division bench orders are staring at the face.
Well,
Division bench judgments are staring at your face.
because
You have been imposed with cost of 2 lakhs.
true. So I have to
Maybe on account of such, you have decided to hold a separate examination. But
Correct.
where is the manner and procedure? That I want to see.
may I
Come back
answer.
with better instruction.
That would be better.
Sorry, sir. You have to
No.
cross very hurdle.
But that's the beauty of. But we are all of us are having a beautiful learning experiences.
The learning is, I told you, learning is reciprocal. As because I have some experience which I am sharing this much. Asun. Heard Mr. Dhar? Fixed motion and distribution will be taken up from.
Lordship, in item number 43, there is a inadvertent mistake in the cost title, Your Lordship. There are address some to be somewhere else and it should be somewhere else in the writ petition, Your Lordship. In item number 43, leave may be granted to correction of the cost title of the respondent 6 and 7.
Item number?
43, 9578.
Huh.
There must be an inadvertent mistake in the cost title of the respondent number 6 and 7. Their address is wrongly put in the writ petition.
Leave is granted to the learned advocate for the
My lord, Monday from 10:30, my lord, whole day, my lord.
No, only
First,
first.
and my lord, Tuesday, Wednesday, my lord, Mr. Bhattacharya has problem, my lord, just now, Monday.